बाकी लोग कर दो सगळ्यांना नहीं एडमिट ठीक है शुरू कर
हे चालू IPR वेबिनारच्या निमित्तानं आपणा सर्वांचं स्वागत करतो.
ऑल इंडिया
इंग्लिश नॅशनल लेवल सेमिनार ऑनलाइन. I am Dr. Surya Gunjal, Director SICA, YCMU Nasik. Would like to welcome all for this webinar. We have with us Honorable Vice Chancellor Yashwantrao Chauhan, Maharashtra Open University, Nasik. We have my colleagues, Dr. Hemant Rajguru, Dr. Ram Thakar, and Dr. Dhananjay Mane. I would like to also welcome our resource person, Dr. Suhas Kulkarni from IPR office and Principal Mahesh Betkar from College of
Kumaraswamy Mahavidyalaya.
KST College, Ausa. So friends, IPR is a very important issue as far as the intellectual property rights related to education, agriculture, industry, and many other fields is important. So our Professor Mane has initiated the idea to conduct the webinar on IPR, and he selected the experts from the field. I would like to welcome the expert Dr. Kulkarni and Principal Mahesh Betkar. See, initially we were thinking about to focus on some issues, like we would like to focus IPR in education, IPR in agriculture, IPR in health sciences. So in general, we'll talk on the IPR, but I will request the experts to focus on the IPR in education, how IPR can be used in education by the professors and teachers working in the university, IPR in research, IPR in consultancy, IPR in extension, so that people interested in this area will be enlightened. I would again like to welcome all, and I would like to request Honorable Vice Chancellor to enlighten us on the issue.
Professor Surya Gunjal, Dr. Dhananjay Mane, Dr. Hemant Rajguru, Dr. Ram Thakre, and all my colleagues from Yashwantrao Chauhan, Maharashtra Open University. And today's speaker, Dr. Suhas Kulkarni ji, Assistant Controller of Patents and Design, and also other speaker, Dr. Mahesh Betkar, Principal of Sri Kumaraswamy Mahavidyalaya, who will be dealing with the process of patent system in India. I'm really happy to see that there is an overwhelming response to this webinar. Around 800 people, almost all over India. The interest people have on this patent or intellectual property rights, it shows really, I think, a big, response. That is how I see that the importance of intellectual property. It shows the importance of intellectual property, as rightly said by Professor Gunjal, that because as a university, as a college, is one of the important activity as a part of NAC process. I think every teacher and every administrator of the university and the colleges should understand, and they should also sensitize about this process. I think Dr. Dhananjay Mane, I think in a right time, I think he has organized this webinar, and which will be, I hope, it will help all our teachers and administrators to know about this activity, which is very important activity as a part of NAC process. I'm sorry, I'm not really that. Have a knowledge of this intellectual property side. I'm also new to this area. I think this is what I hope today Dr. Suhas Kulkarni ji and Dr. Mahesh Bedkarji will definitely will give us all the input so that we will be mostly, know about this process, and which will be helpful not only as a part of NAC process, but also all our teachers who also present a lot of papers and a lot of other things will also have this can also declare them certain things how they can put it in the patent form. So this is I think I'll thank you for giving me this opportunity to welcome you all. I once more welcome, and I will now request Dr. Dhananjay Mane, who is the coordinator of this webinar, to speak.
Respected Vice Chancellor of our university, Professor E. Vainandan sir, the Director of SICA, Professor Gunjal sir, my colleague, Dr. Hemant Rajguru, Dr. Ram Thakur, and the technical assistant, Mr. Abhay Kulkarni and his team, and all fellow participants. I welcome you all for this national webinar on intellectual property right. The today's speakers are Dr. Suhas Kulkarni, who is working as an assistant controller of patents and designs at Indian Patent Office, Mumbai. And another speaker is Principal Dr. Mahesh Bedkar, who is working as a professor in physics at Kumaraswamy College, Ausa, District Latur. The today's session first will conduct Dr. Suhas Kulkarni on overview of intellectual property rights in the first session, and on the second session, Dr. Mahesh Bedkar will deliver on process of filing the patents. Friends, I will give the brief introduction of Dr. Suhas Kulkarni at first, and I welcome Dr. Suhas Kulkarni on the occasion of this national webinar on behalf of Yashwantrao Chauhan Maharashtra Open University, Nasik. Dr. Suhas Kulkarni did his PhD in chemistry on the topic process chemistry and analytical method development. And later on, he completed his LLM in commercial laws in 2017. He joined the patent office in 2003 as an examiner of patent and design in chemical group, deals with the search and examination of patents in the field of pharmaceuticals and chemicals. He has a vast experience of filing the patents in Indian Patent Office, Mumbai. He used to deliver the lecture at Dr. Babasaheb Ambedkar Marathwada University, UGC Academic Staff College many times and all over the India also. From 2014, he is working as assistant controller of patents and designs, dealing with the chemicals and pharmaceutical applications for patents. So he engaged with this GPM, General Patent Matters of Patent Office, dealing with the post-grant opposition, Right to Information Act, RTI, court matters pertaining to appeals, reoppositions, and so on. So without wasting the time, I would like to request Dr. Suhas Kulkarni to deliver the lecture on intellectual property right, an overview to the audience. Dr. Suhas Kulkarni, I welcome you for this national webinar. Suhas Kulkarni.
पहले बार
Kulkarni sir, can you share the? Yes.
Okay.
Kulkarni.
वीडियो बंद है हाँ यस सर you're yeah
sorry. Okay?
Okay sir, okay.
Yes.
Okay, do we start?
शुरू कर सर can you start?
Kulkarni sir, can you start?
Yeah, I can.
Yeah, start sir.
Okay, to start with that, in my first thing, I will just first explain what is meant by the intellectual property rights. Then I will take you through the different types of intellectual property rights. And in addition to that, I will introduce you some of the basics of IPR. Being an academician, so everyone may be interested that everyone be interested to find out that what is the intellectual property, because this is the gathering of the all intellectuals, and all ideas comes from the intellectual people, whatever they make new and inventive things. But unfortunately, they are not aware about that what is meant by the intellectual property. To explain that, I'll just explain what is the what is meant by the property, and then it may give some light on the topic that what I am talking about. As everyone must know that we are pursuing to create a property. The property is in the form of the home, in the form of the land, in the form of the some consumer goods like a car, TV, and everything. What we own, what we have a possession, what we enjoy it properly. That's the property. That is all that form of the property is called as a tangible form of the property, because that we have a physical possession of that, whereas another form of the property what I am talking about is the intangible form of the property, where the property do exist, but the property is in the name of the owner as a credit to him, and it is a matter of fact that how he converts that credit into the tangible form of the property. So I think by the property, it has been clear that what property I'm talking about. I'm talking about really what I mean is the property, what is we actually pursuing day and night together. This property, the intellectual property, what I'm talking about is for which whatever the word intellectual, that means whatever creation of the mind is coming out of the mind of a person, and that intellect when he used to create something or to create some uh, novel thing, then that intellect which has been employed there to create some new good item or a product, that intellect associated with the property, that is the intellectual property. And right, it means right is in the form of the legal rights, what I'm talking about. The right is in the form of the uh, utilization of the property or the proper ownership of the property in the name of the creator of a person who have been creating that property. So the term intellectual property right is in the is for the purpose that whatever creation of a mind is being created, and ownership over that is being achieved by the person who creating it, is the intellectual property right. So rights created over the novel inventive things created out of the mind of a person is being called as the intellectual property right. I think I've been briefly introduced the term what is being called as the intellectual property right. Is it? So as the intellectual property rights are the different types of the intellectual property rights do exist. Briefly, uh, these properties are being divided into two main types of the property. One is being called as the industrial property, and another one is being called as the copyright. So the word copyright has been everybody been quite a bit of way is aware about that. The same way, industrial properties are the name you may be familiar with that, or I may take into that, help you to understand the different types of the industrial properties. Industrial properties, namely 4 5 different types of the industrial properties, which has been broadly, which has been day and today people here. One of that is called as the design, trademarks, patents, geographical indications, and other 2 3 different types of there. In due course of the lecture, I will take it back. This is the brief overview of the lecture what I'm going to talk about. So I think by this time I've been created some base for understanding that what is I'm going to talk about and what I'm going to introduce you about. I'm going to introduce you about the intellectual property rights. Intellectual property rights are nothing but the rights created over the creation of a mind of a person, and these rights have been over the creation of a mind of a person. So that presentation has been shared with everyone, so I don't need to. So it has been clear by this time that's what is meant by the intellectual property rights. The term I have been clear about, and as I told you that the intellectual property rights are divided into 2 types of the 2 main categories. Industrial properties includes the patents for invention, trademarks, industrial designs, geographical indications that includes the symbols, names, images used in the commerce, and the copyright used for the copyright which has been created over the literary and artistic work. As sir told me that intellectual property we try to learn from the academician's point of view. So the copyright is one of the most important things where the academicians are mostly involved, irrespective of the branch or irrespective of the discipline what they are talking about. Uh, so the different types of the intellectual property rights have been categorized as that the copyrights and the related rights. I'll explain what is meant by the copyright and what is meant by the related rights also later on. Then it's trademarks, trade names, service marks, geographical indications, industrial designs, patents, layout designs of integrated circuits, and undisclosed information or trade secrets. These are the basic. These are the types of the different intellectual property rights. Uh, First, we'll start with the industrial properties. As I told you, the industrial properties, which has been mainly used in industry, it does not mean that the academicians cannot own that. Academicians do part of these industrial properties very much. I'll explain as it comes through, but to understand different types of industrial properties, which is one of the type of the intellectual property, that's the trademarks, trade names, and service marks. Everyone of us are familiar with the trademarks or the service marks, which we the products with which it has been associated. Whatever products we use during every time, all the daytime, that products has been marked by some particular symbol or a name by which we identify it. How we identify it by reading it or by seeing the color of that. But what that symbols, and what that particularly trademark and how it is being called the intellectual property. Just if you understand the trade name or particularly symbol by which the product has been identified, it has been given certain impression in our mind about the quality or the goodwill which has been the product has created in our mind, and that product has been identified by the particular symbol or by a particular name. If we take a, for example, a very genuine example or a very common example, say the name of a Parle G biscuit. If we take a Parle G biscuit and if we take mistakenly we take an identical pack of a biscuit and taste it, then we do not find identical taste of a Parle G as it has been there. Or similarly for similarly in case of the but similarly, in case of the toothpaste, if you see the if we whatever the toothpaste we use, if we change the toothpaste brand, then we don't have get a similar freshness in the morning as it is been we are customized to. So that's the trademark or trade name by which it has been identified. So whatever goodwill created by a certain name or by a certain symbol in our mind is by which it has been identified. That is why it has been called as. Sir. नाही मी नव्हतं केलं तुम्ही केलं नाही आहे का कुठून होतं ते एक सेकंड ना कुठून नव्हतं ते स्क्रीनशॉटचा ऑप्शन कुठे येतो हा नाही सर मी मेल केला होता ना सर तिथूनच हा हा दिसलं केला स्क्रीन वन आलं का कोणाचा बाकीचं सगळं कुठे गेलं इज इट ओके
सर कंटिन्यू करा
ओके ठीक आहे
ओके सर
हा पण ओके so trademarks or trade services, as it's been mentioned, that the trademarks or trade names are nothing but the symbols and the names associated with the particular products, and this particular product has been identified by the quality of that product or the goodwill created by that product in the mind of the customers. So the quality, the creation of that goodwill is been associated with a particular product. So the product is been identified by particular name and symbols. So that is been called as a trademarks. Similarly, the service mark is there. Mm, the service marks associated particularly with the services, and the services has been identified certain marks so that services are being differentiated and identified with a particular name and symbol. So the Those name and symbols associated with the services are called as the service marks. In particularly the service marks which have been there. For instance, different types of services which we use routinely, such as the telephone services or the insurance services, even the electricity services, or whatever types of services which you use and identify by a particular name or symbols that is being called as a service marks. So to understand that, what is meant by the trademark or trademark, whatever type it has been written as a recognizable sign, design, or an expression which identifies product or services of a particular source from those of the others. Although the trademarks used to identify services are called service marks. Trademarks owners can be individuals or business organizations or a legal entity. It means it can be owned by an individual as well as a legal person. Legal persons are nothing but those persons which has been created by the act of law, such as university or colleges or any industry that is been called as the legal. Then trademark can be located at any place of the product to identify it is distinctively, so that it can be placed at anywhere on the table. For example, the distinctive trademarks of the Pepsi Cola or the Coca Cola, that's very well known. Similarly, the other names which has been here, I'm not going in details of that because trademarks is such a common thing to understand. You take a name of any product by which it has been identified, it comes into the mind of people. So this is the way how the trademarks has been there, and trademarks is the form of the industrial property, which is nothing but the one of the intellectual property. I'll go briefly. I'll make a reference to the trade dress or a trade secret. This is also a particular type of the intellectual property. Trade dress is a legal term which is generally refers to the visual appearance of a product or its packaging, even the design of a building or that signifies the source of the product to the customer. The trade dress is a form of the intellectual property, whereas trade secret is a particularly a formula, practice, process, design, instrument, or a pattern, commercial method, compilation of information not generally known, reasonably ascertainable by others, which is a which of the business that is been called as a trade secret. That means it is the process or a formula by which the business or a particular product can be formed. It is, so it is called as a trade secret. Then we'll come to the very interesting type of intellectual property, which is called as the geographical indications. Most of the products, not only the agriculture products, even the man-made products, also identified by a particular location of a location or a territory or even a name of a town or a village or a place by which it has been identified. These products have certain characteristics over the other products, over the other identical products because of the place of its origin. By which, because of the place of origin, that the place of origin attributes certain peculiar characteristics in the product. So to make it special, and that is the reason it has been called as geographical indications. It is actually a type of a community type of intellectual property which is been associated with the people associated people residing in a particular territory or a geographical location by which it has been identified. This is the reason why it has been called as a geographical indication. Uh, to come to the slide, geographical indication is a sign used on a good that have a specific geographical location and possesses a qualities of a reputation solely due to the place of origin. Geographical indication is a name or a sign used to identify certain products which corresponds to a specific geographical location It can be a town, region, or a country. Such good enjoys an advantage over the competing goods solely because of their geographical origin, which thus becomes a kind of a intellectual property, and it is being internationally protected. Plus, a geographical indication is different from trademark or trades different from a trademark because trademark is a sign which distinguishes the product and services of an enterprise from those of the others. The owner of the trademark is entitled to exclude others from the others to use from the others. Uh, Naturally, those who owns the trademarks or they can refrain the others from utilizing it. Uh, Coming back to the geographical indications, there are certain different types of the products which has been associated with that. For example, you can name any product which has been famous from your own place. For example, here the non-agricultural goods such as the Kolhapuri chappals from the Kolhapur is been identified by a place where it is originated, or certain different types of drawings or designs or printings which has been made by people of a particular territory. So it has been named by that particular territory. Agriculture goods such as the mango, Alfonso, which has been famous from the Konkan, so it has been named by that, or the Nagpur oranges, or grapes from the Nashik in particular. This has been particularly identified by a particular place of origin, and that place of origin gives this product certain advantage over the other places from where it has been originated, and that is why this has been called as a geographical indications. It is also categorized as a one of the form of the intellectual property, and these geographical indications are internationally protected. So, in case of the basmati rice, if we know the basmati rice which has been cultivated in the Tarai regions of the North India, so it has been having a particular aroma because of the certain chemicals present in that rice, and this is being internationally recognized. So no other country can sell their rice as a basmati rice unless without the permission of the particularly the basmati term which has been owned by the India. So it has been identified like that. There are certain, there are hundreds of the goods which is not only agriculture good, non-agriculture products also there, which has been famously protected internationally also and nationally also. I'm happy to tell you that around 500 different products have been already registered under the geographical indications. I can give you some basic tasks to understand and to find out that what different types of the geographical indications have been located from your registered from your own area. You can Google it and find it out. You will find it a lot of food items, agriculture goods have been protected under this category. Then we come to the another important types of the intellectual property that is called as the industrial designs. So industrial designs, as the name design itself, that means whatever product or whatever things if we come into mind or whatever thing we use, this particular thing, the design of that can be also registered as an intellectual property. For instance, if we take example, all we are watching this presentation on the monitor, if we see the size of, if we see the design of a monitor is a subject matter for the registration under the intellectual property. So the design is also registered as intellectual property. If you see certain goods, the goods have been uh, or the particular design registration number has been engraved there on the product, so nobody can copy it as such it is possible. That's the reason the name has been mentioned there. Coming back to the presentation, industrial design is an ornamental or aesthetic aspect of an article. It may consist of three-dimensional features such as shape or surface, or two-dimensional features such as a pattern of lines or a color, which is part of a design, or it forms a design actually. The design serves as a tool for product differentiation. It serves as a tool for product differentiation and lures customers uh, from because of its enhanced sorry. Bit of interruption. Design serves as a tool for differentiation of a different product differentiation to use the customer or to impress this customer by having special enhanced visual features. Design has nothing to do with the technicalities of the product. It is merely an ornamental or aesthetic aspect of the product. It has nothing to do the technicalities of the product. Then industrial designs are applied to a wide range of the products in industry, handicrafts, watches, jewelry, you name any item that has been having a particular design, and if some novel feature has been incorporated into this design, then these designs are subject matter for the registration, and it can be protected as an intellectual property under the Design Act. Design is distinguished from the trademark or primarily because it constitutes appearance of the product, which is necessarily be distinctive. So earlier intellectual property which I have seen, it's different from the design because the trademark is the name given to a particular name given to a particular product or a services, whereas design is actually the aesthetic or ornamental aspect of the product. Then we'll come to the most widely known form of the intellectual property, which is being called as the patents. Everybody hears the word patents, but unfortunately, what is meant by the patents, some of the people may get confused with that. To explain that, what is meant by the patents, it
क्या
means
पेटेंट कैसे करवा सकते हैं अपना जो आपका वो है IPR होगा इंडियन या इंटरनेशनल पेटेंट राइट्स
hello. The patents, as it has been mentioned there, what is meant by the word patent? The patent is nothing but to lay open something. That means to open and disclose something. What that disclosure is and what for the patents are obtained. Let me tell you that as an academicians, you people are quite aware about doing a research. I also did a research, but in a single laboratory, if few people are working, then no two people knowing that what the other person is doing. Why it has been that? Because we want to protect it from being getting copied by the others. That's the reason we keep it in a secret. We don't disclose it that what is this work, what we are working on. But in contrast to that, what the patent stands for to lay open. What the government is telling you to come and disclose it to the government. Government will give you ownership over that. Government gives you exclusivity over your disclosure for certain period of times. That certain period of time is extended is up to 20 years. That means if you get a patent over your own work, then it has been monopolized in the name of you for 20 years. So that is called as the patents. That means what is the patent? Patent is nothing but an exclusive right given by the government to the inventor or a applicant to whoever they assign their right to the applicant for a 20 years of the period, 20 years from the date of filing of an application. So that is the patent. The patent right is nothing but the right to create monopoly over the disclosure of the invention. That disclosure is nothing but what work which you have been carried out, what research you have been carried out, Over that, over that you get a monopoly, you get an exclusivity. That exclusivity or monopoly is what for no one can manufacture it without your permission. No one can sell it without your permission. No one can import it without your permission. No one can do business with that without your permission. So, without your permission, no one can have anything to do with that. You have an absolute ownership over it for 20 years of time, and that exclusivity is stands for is nothing but the patent rights awarded by the government. Uh, Coming back to the slide, patent is a statutory right granted for a limited period of time to an inventor in respect of the invention to exclude any other person from manufacturing, using, selling patented product or from using patented process without due permission of the owner. Uh, the patents are usually granted for the inventions. Now coming to the what it protects, that the patent is granted for the inventions. An invention is nothing but a new product or a process involving an inventory step and useful in industry. I'm not going details of the definition of invention right now because we are just getting an overview or different types of the intellectual property rights. So the a patent system is a very old system. It's been since there last 200 years or more. Even in India, we have a patent system since 1856. So where the inventions has been protected under the Invention Protection Act since the day one of the British rule in India. So the patents have been protected. Invention has been protected in India since then. We have long systems, but unfortunately, we are lagging behind now to file and protect our own inventions. We are more oriented towards the publication society rather than creating a ownership over the to just create a spark in the mind of the all academicians. I'll just briefly explain you how many patent applications China files and how many patent applications India file. Then you will be surprised to know that China last year in China there were 10 lakhs application filed, whereas in India we have hardly 50,000 applications. To compare with the other developed countries, if we compare with the Japan, they have around 4 lakhs applications, whereas we have 50,000 applications. European Union or European countries file around 350,000 applications, whereas we have stands with the 50,000 or even less than that. And to add more pain to that 50,000 patent applications, if we see the most of the applications, almost 80% of that applications come from the foreigners, which is originated in other countries rather than India, whereas they try to create monopoly over that. They may include the universities abroad, universities located abroad, or they may include the multinational corporations the individuals there, whereas 20% of the patents originated in India. Out of that, maybe 5% or even less than 5% comes from the academicians. Unfortunately, it's a very sorry state of the situation, but we need to improve on that. I think the manager has taken a right initiative to enlighten all the faculties or academicians about the patents no, intellectual property rights. So maybe out of this seminar or webinar, we get some few applications, at least 50 applications come out of this webinar. Then manager, it is really cheers for you. Okay, coming back to the presentation, then another form of the intellectual property right is the layout of layout of layout designs of integrated circuits. As we know that those who are particularly from the electronics engineer or computer or software engineers, they are aware about that what is meant by the layout or integrated circuits. These integrated circuits designs also been protected under the intellectual property rights. I'm not going in much details of this, but these have been protected under the IPR. Then undisclosed information, that's a trade secret, as it has been briefly explained that Already I explained you what is meant by the undisclosed information or a trade secret. This is also protected under the intellectual property. But in India, we don't have the protection under the Trade Secret Act, but it is been protected under the Contract Act, whereas the contract is been there between the employer and employee to protect the undisclosed information. Okay, we'll come to the next type of the intellectual property, which is a very important one as far as the academicians are concerned. Irrespective of that, basically they can have this particular type of the intellectual property, and the value of this is been. You can ask your publisher how what is the value of the copyright and how much money is associated with that. Let's see what is the copyright. Copyright gives the creator of the original work exclusive right to it, usually for a limited period, limited time. Copyright may apply to a wide range of creative, intellectual, artistic form of the work. What copyright do not cover? Copyright do not cover the ideas or information themselves. Only in the, whereas it covers the form or the manner in which it is been expressed. Most importantly, copyright do not cover the ideas or information, whereas copyright covers the form or manner in which they are expressed. It is been covered by that. The copyrights includes the related rights also. That's the rights of the performer, producers of the sound recording, broadcasting organizations, extra. I'll explain you what is meant by that. So that's the reason why it has been called as the copyright is a bundle of rights. Because along with the copyright, there are the rights of the authors, such as right of the performers or the producers or the sound recordings or a broadcasting organization is been covered under that. But in particularly, if we take an example of any lyrics or any song, then we can find out that so many people get involved into the creation of a song or a movie. That particular movie or a song which is being covered there is being a copyright owned by a owner of this song or a movie, where, whereas he owned the rights of the others such as performers, producers, sound recorders, or the broadcasting organizations, extra, etc. Because he is the ultimate owner of that, so the others' rights has been also been owned by him. They have been suitably compensated for it. So that is why it has been called as the copyright is a bundle of rights and not a single right. And the copyright is obtained for the intellectual artistic form of the work. What is meant by this work? Different types of the works are being mentioned there. These works is nothing but the creation of a human mind in the field of literature, music, art, audiovisual work. The copyright the owner of a copyright has a right not only over the original work but also creative work derived from the original work. It means that the translation or adaptation or enactment of a particular work or a production of a film based on the original work, that means still the original work or the literary information who will be created, he has a ownership over the adopted work or in a translation work also. Such rights related to the copyright are also called as the related rights. There are neighboring rights on copyrights which protects the perform rights of the performers or a performing artist or a phonograms or broadcasters, etc. Related rights or neighboring rights are used as an interchangeability. So this is the brief overview of the intellectual property rights which is being covered here. I'm open for the question if anyone likes that, or if you need some more information, we can go deeper. Vanessa?
The session is open for discussion. If the participants have any questions or queries, please raise your hands in the chat box and ask the direct question to the Dr. Kulkarni sir. सर काही विचार चॅट बॉक्स मध्ये बघा आपण. Yes, Dr. Kulkarni sir.
Yes, sir.
Is there any legal procedure to file a patent from the academic field? Can you assist to the professors or the researcher to file a patent on their work? What is the procedure?
Sir, filing a patent application from academicians or professors is not distinguished from the others. It's an identical process like others, they have to follow it. Particularly if we see, I think second lecture will going in much details of that. But to help you understand that different types of the forms are there. Anyone who interested to do so, they can visit to the patent office website which is the ipindia.nic.in. You can Google it and find it out the patent office website. Different forms are there. It's not so easy to see all that forms and file a patent application. But what I like to see a proper approach to do so. If you are doing on your own without taking assistance from the lawyer or a patent agent, then I will suggest you to go on the search page of the patent office, search some patent applications or Google some patent applications from your own field, whatever the field you are working on. Google it, find out your own interest, patent applications or patents on the website. Read that patents. Once, if you read for 10, 15 different patents or patent applications from this website, then you will get a suitable idea that there is how to write the patent application. Uh, Once you got this idea, then you can visit to the patent office website, download all the forms from there. There are basic forms, as I mentioned you, the form 1 is there. Form 2 is actually what is the disclosure of your invention, what patent application you are making out. Then form 3 is there, form 5 is there, form 9 and form 18. I'll repeat, the basic forms required to make a patent application is form 1, 2, 3, 5, 9 and 18. These are the forms required to make a patent application to the patent office. You just see the patent office website, all information is been there. Everything is there. Apart from that, patent office has a helpline. You can call on this helpline, get the guidance from the experts sitting there during the office hours. All the any one of our officer is always available online there to help the patent to help anyone who has been calling there. So you can use this helpline also to get guidance to file the patent application.
Okay, sir. Sir, Munja sir.
Anybody from the audience? Prakash Barve.
Sir.
You want to ask any IPR about library sciences?
Hello.
हा बोला.
IPR आणि कॉपीराइट बद्दल बऱ्याच वेळेस गैरसमज असतो, तो फक्त एकदा क्लिअर झाला पाहिजे असं वाटतं सर.
Copyright is one of the form of the intellectual property right.
Book form.
Copyright
Intellectual. intellectual property rights are divided into two major types of the properties. One is called as the copyright and another one is called as the industrial properties. Whereas copyright is one of the form of the intellectual property. Copyright is obtained for the any creation of a mind in the field of literature, music, art, audiovisual work, or cinematography, etc. For that, the copyright, whatever the creation of mind in the field of the literature, music, art, that has been categorized under the copyright. So there need not to be a confusion. Any copyright is one of the form of the intellectual property.
Thank you, sir.
So if there is no any questions or queries, we'll close this session and I will invite Dr. Bedkar for the second session. Thank you very much, Dr. Kulkarni sir, for your nice introduction regarding the IPR, and we will arrange again in future the detailed procedure of filing the patents, what is the detail in copyright, trademarks, and geographical symbols.
Definitely, sir. I'd like
We'll
to.
be happy to see you again at YCM in Nasik.
Sure, sir. Yes.
Thank you, sir.
Thank you, sir.
Friends, the second session will be conducted by Dr. Mahesh Bedkar, who is working as principal at Kumar Swami College, Ausa district, Latur. Professor Bedkar had did his PhD in material science in subject of physics. He has a vast teaching experience of more than 30 years, and he delivered the lectures on patent system in India, process of NAC. He has been invited for various national and international conferences as a speaker at Jakarta, Phuket, Singapore, and in India also. He is a member of editorial board on 6 journals in the India and abroad also. He has published more than 50 research papers and filed 7 patents, Indian patents and international classified patents. And he delivered 47 invited talks related to patent system in India and process of NAC. So without spending much more time, I would like to invite Principal Mahesh Bedkar to deliver his talk on process of filing the patents in India. Dr. Bedkar, please.
सर मी ऐकू येते माझा स्क्रीन दिसते
Yes, sir.
Yes, sir.
Thank you, sir. I would like to express sincere thanks with the YCM University Honorable Vice Chancellor, Honorable Registrar, Dr. Dhananjay Mane sir, and all the authorities of the universities, those who are taking efforts for publishing the IPR session throughout India, and they joined all the academicians, teachers from all the country. I am here after listening a best and knowledgeful lecture of Dr. Suhas Kulkarni sir. I am here to express few my thoughts on the patent, as I have allowed it to express on the patent filing system. Step by step we go in the process to the our lecture. Thank you, sir. Now the objective of my presentation is to know the IPs and IPRs, to create awareness on IPRs, and to know the process of filing patents. These are 3 objectives of my this lecture. I will try to finish within the allotted time to me 1 hour. Since in this topic, I would like to touch the points: what is IPR, what are IPR types, what is the IPR term, what are the infringement in IPR, what are the benefits of IPR, what is the patent, what is the patent filing process, what are the useful websites for applying patents, and few examples and news related to patents. We will go step by step in this way. Let us see. First slide is the I. In the word IPR, First word is the I. What is I? As Dr. Kulkarni sir said that I is the intellect, means intellect thinking of a mind. We always think so many things at a time in our mind, but that thinking of intellectual mind is going to some give a product. That is the intellect product. So that is the intellect thinking of a mind is known as the intellectual. If the intellectual mind form a product, that is here as the example as a bulb, then that is known as the intellectual property. The property formed by the thinking of an intellectual property, that is the intellectual property. And thirdly, let us see, if we not register that invention of us on a registration process, then the few persons from the society try to stolen our knowledge without, if you not register that property on our name. If you identify, if you invented all these things but not registered, so these things happen before the intellectual property of registration. What happens if we register that property on our name? If we register that invention our name after registration, we get the right known as the right given over the creations of a mind known as intellectual property rights. It's clear that the intellect things which came from as a property, and if they register, then we get the rights on that property to use to enjoy that rights. That is known as the intellectual property rights. Let us see what are the types of intellectual properties. There are 7 types of intellectual properties. We just see the 7 types of intellectual property. First is the trademark. All these things have been explained very beautifully by resource person Dr. Suhas sir, but still I would like to touch this point. Let us see here there are some symbols known as the trademark. We can identify that product which is coming from that company, which is product of that company by seeing this symbol. There is no restriction for creating the trademark of a company, its own design for that. If once that is registered, that becomes that property. Here Coca-Cola, Jack and Johnny is the just signature, one slogan Amul, one Nirma and Parle-G. So these are the symbols which are very different and they are identified as a trademark of that particular product. Once they are registered, they get the right on that intellectual property. Secondly, trade secrets. What are the trade secrets? When an organization improves or makes some product or some process that they want to keep the secret, that is the trade secret. But if you want, they want to register that secrets on the intellectual property, then that becomes a trade secrets. And by using the trade secret, that particular organization progresses. There is no restriction to register the trade secret. There are so many trade secrets of the world which are not registered yet, but by using that knowledge, that organization's company is still in progress. So what is the trade secret? Trade secret is known to limited peoples. There is no legal formalities required to obtain the rights because they are not registered. Though there is no issue of giving any rights to them. They just keep all the information as a secret. That is known as a trade secrets. There are various trade secrets of the world, but I shall give 3 examples. One is the Google search algorithm. When we try to search on a Google, within fraction of second, it gives lakhs of information to you. So that algorithm is still secret from the Google. So that is the Google search algorithm is still trade secret. Second is Coca-Cola. There is no any person who knows the Coca-Cola drink formula. Still it is ahead in the market. So it is the trade secret. Third, New York is the best seller newspaper of the world. What the strategy they are using, they are not knowing to someone. So that these are the few trade secrets which is using that organization for progress of that organization. Secondly, there are geographical indications. As Dr. Suhas Kulkarni said, some few examples why they are needed. Geographical indications are maybe of the man-made, maybe natural, or maybe some product of that particular area. We can identify here Nagpur orange, Basmati rice, Paitan Shati, Kullu shal, Nashik Valley wine. All these are the products. There are some few man-made and few are natural. So product can be registered under one of the IPR, that is known as the geographical indication. By registering that product of that particular area, the product goes to the onward level and it uses the market economy, and no one can the world from can claim that product is from us. So there are 624 up to yet we have registered as the geographical indications of India, and Karnataka is the highest geographical indication registering state of that Maharashtra, and Karnataka has 23 geographical indications. So here is Kolhapuri chappal, Puneri pagdi, Darjeeling tea, Alpacio mango, and this Kanchipuram silk sari. as these are different and they are registered under the geographical indications. Second, one story, it is the Rasgulla from the state Orissa is registered under the geographical indication of Orissa after formatting a committee. Let us leave this one. Fourth is the design and utility product. Means if you have design 2D, 3D model or working model, that can be registered under the fourth IPR, that is known as the registered design. Here you can see few examples, and I have given one example of a particular ornamental. If we go to the more productive famous brands of the ornament, they price so much from that the price of the gold. If there is gold in that ornamental is 30,000 and they charge 1 lakh rupees to us, there are 70,000 rupees for their unique registration of the design. So this is very important. If design is unique, it gives the market to the inventor and it gives the economy to that inventor. Let us see the fifth, that is plants builder right. As our honorable Vice Chancellor said that for our academicians and the university persons, they should want to try some registered IPR on the NAC, not NAC of point view, but their progress of their our country and the university also. So our university is doing research on the plants and breeding all these things. So that product can be registered and plants builder right. If we register that product under plants builder right, which is such as giving very large product within few time and which is not affecting for any diseases. So the tissue culture process, cutting process, seed process, any biotechnology process which is giving new product very large, which is giving very large yield for that product. If the seed is prepared by our university can register it under the plants builder right as the fifth IPR. Let us see the sixth copyright is the tangential media. Means as like our librarian said that what is the copyright or the IPR related to book. So copyright is related to tangential media. Means that media we can hear, listen, watch all these things. This is the painting, software, CD, sound CD, video CD and the books. And the paper, news articles, journal articles, all these are coming under copyright, and there is no need to apply for the copyright application. Once it is published, that publication date is utilized for the getting the copyright to that person. If you are publishing that one, if you are not published, that is not matter. But if you are published, you get the copyright on that your invention, like book article, journal article, your sound system, your sound, your audio or video product. Yeah, that can be get the copyright on that. Since there are some examples here, I would like to share with you. Copyright commences from the moment as work is created and registered. जेव्हा तो प्रॉडक्ट बनवला जातो, पब्लिश केला जातो, तेव्हा त्याला कॉपीराइट मिळतात. Here there are few examples I would like to give. Here Bombay to Goa is the first film, means first slide of that film, and it is registered from 25 May 1982 and it was expired 24th May 1992. Means within these 10 years no one can give the name as a Bombay to Goa to that any film. So that there are few films which is Dawn 1, Dawn 2, Dawn 3. Why there is need to give a name Dawn 1, Dawn 2, Dawn 3? Because of the copyright of that particular period, no any director can give the same name for that. So it is the particular registration of the copyright of that name. Let us go ahead. The seventh IPR is the patent. It is the important IPR, and let us define and explain all these things. What is patent? Patent is a monopoly right granted to a person. एक अधिकार है, सिंगल स्वामित्व अधिकार है, granted to a person, एक आदमी को या ग्रुप ऑफ आदमी को दिया जाता है, who has invented, जिन्होंने इन्वेंट किया है न्यू नॉवेल एंड यूजफुल आर्टिकल, जिन्होंने नया नाविन्यपूर्ण आर्टिकल किया है उसको अधिकार दिया जाता है. An improvement of an existing article. If there is improvement on that existing article, then it can be come under the patent. Mean there are examples of car. Before that we were running car on the diesel, after that petrol, then petrol and diesel, then gas, CNG gas, and now electrical car. So these are the innovations on the same product car. So every time that innovation in that product gets the patent. And the next one is the new process of making an article. Means that the process is new, but article is same. Patent can be granted to that process also. This is the process of granting the patent. This is the definition of the patent. And one more thing is that the article should be capable of industrial application. If there is no any applicability of that product, no patent can be granted. So what is the patent? Patent is a monopoly right. It is the right given by the government to that inventor, for which for new invented new article or useful article, and it may be improvement of an existing article, or it may be the process of making an article. Since there is a single tablet paracetamol, 100 and more than 100 companies are producing paracetamol. So, but process is different. Every time they have to claim for the patent also, for the process of the patent also. There are three things for granting a patent. What are three things? There should be novelty, there should be inventiveness, and there should be utility. These three things should be followed by a patent: novelty, inventiveness, and utility. Let us go next. Since there are examples of the wheel, first of all, wheel from stone, then wooden, but with that some few less work, and then tubeless tire. So this is the improvement in day by day of the same product wheel. So a wheel can be granted for a patent if improved next one also. So same product, if it is improved day by day, then improvement part can get the patent also. Let us see what are the patentable inventions. First of all, we see the patentable inventions. Means we invent something, but if it is patentable, then we can go ahead. If not patentable, we cannot go ahead for that. Let us see. Machines, apparatus, or other articles can be patented. The machines, articles, and other articles which can be used for the industrial purpose or the society purpose, they can be patented. This is the first patentable criteria. Second, the process of method of manufacture. Any process which is innovative one, new one, novel one for making a product, that should be patented, that can be patented, that is process can be patented. Thirdly, the software which is used for the hardware. The single software comes under copyright. But if software is used to run a machine, that software can be patented. Now, the food products, chemicals, medicines, and drugs can be patented, because if we form a medicine and it is the different form of chemical, after that reaction, the main chemicals which are ingredient lose their property and give us new product, innovative product. At that time only we can grant the patent. Not if they are not new one, we cannot patent because they just a mixer one. So food product, if it is new, novel, and having different properties, and chemicals and medicine and drugs can be patented. Let us see which things cannot be patented. Up to now, we have seen which things are patented. Now we see the things which cannot be patented. It's more important than patented thing. Since see, known inventions which are known to public, which are known to world, cannot be patented. This is the first one. Second, inventions which are contrary to natural laws. कोई अगर अपना रूल है, उसको अपोज कर रहा है नेचुरल लॉ का, तो उसको हम पेटेंट नहीं दे सकते. The rules, the inventions which are contrary to natural laws cannot be patented. Thirdly, the against public ethics and morality. Those who have formed, performed, or manufactured by you giving the objective that they are using this product as a against public ethics and morality, they cannot be granted for the patent, applied for the patent. Secondly, causing commercial exploitation. If someone is doing product that is tends to the commercial exploitation of someone's society, then that product cannot be granted for a patent. Fifth one, the things which are harmful to our plant life, animal life, or live thing and environment. So if someone is did some product which is harmful to health of human, animal, plant life, and environmental, so that products cannot be patented. So we have to keep in mind that our product should not harm to the animal health of human, animal, plant life, or environment. Fifth, after that, sixth one, the discovery of scientific principles, which is known to us from ancient days, that we cannot file for a patent. Discovery cannot be filed for scientific discovery, cannot file for the patent. Seventh one, the substance obtained by the admixtures, which are only collected things at a time, that cannot be if there is no chemical reaction, every ingredient shows it's the same nature after filtering for that. So at that time we cannot file admissions because there is no innovation. जसं आपलं लिंबू सरबत आहे, लिंबू सरबत साखर, लिंबाचा रस, पाणी आणि मीठ असा काही प्रकार असतो. त्याला फक्त मिक्स असतं, त्याचा स्वाद बदलतो. परंतु जर आपल्याला ठरवायचं की आपल्याला बाजूला करायचं तर आपण सगळे पदार्थ बाजूला करू शकतो. मीन देर इज नो एनी रिएक्शन इन बिटवीन द इंग्रेडिएंट्स सो दॅट लिंबू सरबत कॅन नॉट बी ज्यूस ऑफ दॅट लेमन कॅन नॉट बी ग्रँटेड फॉर अ पेटंट. सो ऍडमिशन्स कॅन नॉट बी ग्रँटेड फॉर द पेटंट. अँड द प्लांट्स, animals, whole or any part, because they are naturally born, they are naturally growing, so not any part, not any animals, not any plant cannot be granted for a patent. Let us see the method of medical cure. The cure methods cannot be patented, but the equipments used for the medical purpose, curing purpose, that can be patented. Method of medical cure is free knowledge for the society, so it cannot be patented. Nextly, the method of agriculture or horticulture cultivation. The cultivation methods cannot be patented. It is free for the society, but the products used for the agriculture purpose, horticulture purpose can be patented. Let us see 11th one, the traditional knowledge which are knowing to all from ancient days, that cannot be patented. Traditional knowledge cannot be patented. As you know that in turmeric problem, हल्दी घाटाचं युद्ध जे आपल्या डॉक्टर माशेलकरांनी जिंकलं ते कशावर जिंकलं तर आपल्या ट्रेडिशनल नॉलेज मध्ये हल्दीचे जे उपयोग होते वेदापासून लिहिलेले आपल्या ज्या होत्या ते सगळं त्यांना साहित्य दाखवावं लागलं इंटरनॅशनल कोर्टामध्ये. तेव्हा कुठे हल्दीचं पेटंट आपल्या देशासाठी राहिलं. दॅट्स वाय ट्रेडिशनल नॉलेज कॅन नॉट बी पेटेंटेड. अँड लास्ट थिंग इज दॅट the invention related to atomic energy cannot be patented. But if you want to file the invention related to atomic energy, you have to consult to the Atomic Energy Division of the Government of India. If you get permission from that, you can do the research or patent on that atomic energy invention. So these are the things which cannot be patented. Let us see the infringement. Infringement म्हणजे काय? एखादा चांगला प्रॉडक्ट मार्केटमध्ये आल्यानंतर लगेच डुप्लिकेशन सुरू होतं. असं डुप्लिकेशन होऊ नये, त्या कंपनीचं नुकसान होऊ नये म्हणून आपल्याला काय इन्फ्रिजमेंट हा एक कायद्यामध्ये आपल्याला तो बदल केला आहे. एन्क्रोचमेंट इज इन द फिजिकल फॉर्म बट infringement is the IPR form. What is infringement then IPR? Infringement in IPR is unauthorized use, duplication of that product, sale of duplicate material. If someone is doing this thing, that is the infringement in IP cases, intellectual property cases. Let us see the examples. As like our Kulkarni sir said the example of Colgate. So like that, here there are OK and Ole, Colgate and Colgate. These are the two, Bisleri and Billeri. These are the same product, means similar product, but not same. So that one is original, one is duplicate. So someone is doing a duplicate thing and giving some fraud to that company, then that is the infringement in IPR. Let us see an example. Samsung company have fined more than $1 billion because it is stolen some few features of the Apple brand and used for the marketing. So there is international court, and in that court, Samsung fined more than $1 billion. Let us see one news from the Delhi newspaper. This was designed and I have copyright for a few years. Before that, she have used the dress in some function, so it is filed under copyright. 2 crore was filed in the fine for the violation of the copyright. So if someone is encroaching or someone is violating the copyright of IPR Act, there is huge punishment also. And let us see the next part. What can we do the IPR? आपल्याला IPR माहिती झाले, IPR चे प्रकार माहित झाले, पेटेंट कशाला म्हणतात ते माहिती झालं, पेटेंट कशाचं घ्यायचं ते माहित झालं, पेटेंट कशाचं घेत नाही ते माहिती झालं, आणि यानंतर आपण पेटेंट सारख्या चांगल्या प्रॉडक्टला जर डुप्लिकेट करून जर कुणी विकण्याचा प्रयत्न केला तर शिक्षा होऊ शकते हे माहित झालं. आता आपण काय करू शकतो? व्हॉट कॅन वी डू दी IPR? आपल्याकडे IPR आहे. IPR असल्यानंतर आपण काय करू शकतो? IPR इज लाईक अ फिजिकल प्रॉपर्टी. मीन्स एज लाईक फिजिकल प्रॉपर्टी कॅन बी असाइन्ड. काही दिवसासाठी तारण ठेवू शकतो आपण. फिजिकल प्रॉपर्टी कॅन बी सोल्ड. We can sold our physical property, and thirdly, physical property can be gifted. Same thing, IPR can be assigned for few years for get economical benefit. Secondly, physical property can be gift sold. We can sold our IPRs also for our economical benefit. And thirdly, we can gift the IPR to someone. After giving gift that someone, that second person which we have gifted, that enjoys the all the benefits of the IPR, not the inventor. So these are the three things we can done with the intellectual property rights certificate to us. Let us suppose one company is having some loss. So at that time, that company should not sell the physical property, that like plot, all these machineries, but they have the patent. Then they can sell the patent and they can recover their loss for that. So it's the benefit of that holding a IPR to a private sector. Let us see few examples of the patents. Anti-eating mask. I am giving you very simple example, not complicated example. What is this? Is the simple anti-eating mask. If someone is medical doctor is preferring someone to not eat frequently, then we can make this machine. We can make this design and we can do law for that person for not eating something. So it is a very simple patent. Apply a patent and granting patent, granted patent, that is known as the anti-itching face mask. Secondly, one is the back scratching. It is the simple problem, daily problem to us. If someone want to develop, someone have developed that product and have filed the patent, it is the patent on back scratching. Means I am showing the examples, very simple examples, not complicated example. This is the very routine example, and they have get the patent. Here also a patent on that headache village. Headache village means क्या? एखाद्या ऑफिसमध्ये जर कर्मचारी काम करत नसतील असं ह्या अधिकाऱ्याला जाणवलं आणि त्या अधिकाऱ्याने मग पाठ दुखणाऱ्या अशा सर्व कर्मचाऱ्यांसाठी असा एक व्हील तयार केला आणि त्या व्हीलहून ही ट्रीटमेंट दिलेली आहे आणि त्यातून त्याला पेटेंट मिळालेला आहे आणि ऑफिसची इफिशियन्सी सुद्धा वाढलेली आहे. सो दीज आर द व्हेरी सिंपल एक्झाम्पल्स विच कॅन बी युज्ड फॉर टू फाईल अ पेटंट. सेकंडली, आय प्रोटेक्टर फॉर चिकन. मुळात कोंबडी आणि तिचा चष्मा याचा काही संबंध नसतो, परंतु या कोंबडीला चष्मा काय केला, त्याची डिझाईन कशी असावी, ती कशी त्याच्या डोक्यावर बसावी, त्याचा उपयोग काय. इफ यू से इन दिस ऑल दिस थिंग इन ऑब्जेक्टिव्ह, then that can be granted for a patent. Means in 1903 patent was granted on the eye protector for chicken. These are not a very large issue but very simple things which can get the patent also. I would like to share one example of a shop which is at Karan named as Patent Dhar Kendra, because that person, that owner used to this name because he uses a particular sharpness equipment for sharpening the cane cutting equipment. So this is the Patent Dhar Kendra is the name of a shop. Let us see, there are 8 wonders of the world of patent. जसं आपण जगातले आश्चर्य म्हणतो तसे पेटेंटच्या क्षेत्रातले अशी 8 आश्चर्य आहेत जी आश्चर्य जगात अत्यंत प्रगती करून गेली आणि त्या आश्चर्याची आपण एक नोंद घेऊया. द लाईट बल्ब, the internal combustion engine. Light bulb means the light bulb, internal combustion engines, the telephone, computer, Bluetooth, Maglev technology, the Fire Hi-Fi malware system, and the Google page RAM. These are the 8 wonders of the in the world of the patent, from which the world have technologically very ahead from progress for that. So these 8 patents are known as the great wonders of the patent world. Let us see the main issue of our lecture is the filing. After knowing the knowledge of about some patent, the process, now let us go towards the filing of a patent. How we can file, who can file, where can file. All these things can be seen in the next part towards the filing of a patent. Let us see. First of all, before filing a patent, we have to sit very concentratively and write down the idea as much as possible. Means we have to write a very detailed manner that idea which we are going to invent. So there should be no any aspect which will remain behind, and one can claim the patent on that also. So we have to write very detailed the idea in maybe roughly, but we have to write every dimension of that particular invention. Suppose if you like to do the invention on pen, how it should be, how it clipped, how ink will be filled, how it should be, all these things. So every matter of that particular invention should be written, maybe roughly but in detail. Secondly, we have to check patentability of the subject matter. Once we decided to file a patent on a particular subject, we have got some rough situation, but every dimension of that situation, every dimension of that our invention, then we have to look the patentability subject matter. If the matter is not patentable, then our all the process gets lapsed. So first, secondly, we have to check that whether it can be patented or not, patentability or not. And if we confirm that this is the product is very nice, we can go ahead for that, and it gives commercial benefit or the name to our institute, then we can go ahead for that, we can patent that thing. Let us see the third steps are required for filing. First of all, for filing the patent, once you have decided to file a patent upon particular subject, drafting few things related to that, we have to first search. First, our step is to search. First step is searching the related patents on the international search engine. Secondly, we have to draft, and thirdly, we have to send. First search, second draft, third is sending. Let us see one by one. What is first? It is the searching one. We have to search the patent on the international patent search engines, which I am giving here. I am giving example 5 search engines. We have to search on that website, so that there should be our new one. First of all, Google patents. You can search international patents on Google patent, USPTO patent full text search. In past, Indian patent filing system, we can search on this website also. You can search on ESP, or you can search on WIPO, World Intellectual Property Organization. So these are the 5 search engines where you can see, or you can search, you can download the related patents, we can study the patents for reference for learning the draft and how much it is filed, what is the idea of that patent, how if anybody is filed or not. So we have to search these 5 engines, and there is 70 years data here. Thousands of patents, lakhs of patents are available here. One can go for searching that, and the most related inventions you can collect. As like we draft a paper, publish our paper, then we give some references which are most related to that. So you have to give most related inventions from that. In that invention, this much part is covered. We have improved this much. In this invention, this much part is covered. We have to we have improved this one. So all you have to give the references for that by searching this on the website. And the third, I will give you the example of that. If there is simple example of pen, I have written one word PEN on that. So after writing one PEN in that search engine, there are 1,62,225 patents on a pen. Please listen, 1,62,225 patents are filed on the single pen. So every time it is improved, every time it got a patent. So everything, if it is improved existing knowledge, that gives the patent one. Let us, second step is drafting. Drafting is more important. As like Dr. Suhas Kulkarni sir said, patent officer from the Mumbai. If you learn, if you read some related papers or patents of our invention, then you get idea of writing the drafting. As like it's a special language of drafting the patent. You can get the knowledge, and we can go to the drafting also. And what is the structure of an application? As like our paper, research paper. As like our research paper, we have objective, abstract, then methodology, then characterization, then conclusion. Same thing, the structure of patent is like this. First of all, it is the title of invention. It should be unique one. First of all, you choose the title for registration. Second, now we come to the subject matter. In subject matter, we have to give the background of an invention. Why we are inventing this one? You have to give detailed background of invention, and then prior art details. Prior art details means the details of the patent which are related to our patent. So we have to give in prior art method, and then we have to write the objective of the invention. What are the objectives of the invention? We have to write. Then the detailed description with drawing and characterization. This is most important, because once we submit that application, the patent examiner goes through the detailed description for reading this, and so that we have to give the detailed description, drawing, characterization, supporting diagrams, all these things supportive to our patent. And lastly, it is the claims. Claims means which new part you want to file or for the claim. You want to claim on that part, that are the claims, and this should also important one, because someone may study your patent and give new patent, generate new patent, which you have loosened from that invented, but you have loosened that part, and that person can grant the claims for that patent also. And third step is sending, where we have to send the patent. There are two types of method of sending. One is the manual sending. Go to the office, post office, download the forms, print out the forms, register that office, or go to the office. All these things is manual thing. But nowadays, patent office have given an opportunity or given a facility to us to file e-sending also. Without going out of our home, we can download the patent, we can search the patent, we can draft the patent, and we can file the patent, we can send the patent with particular fees. So e-sending is preferable in the corona period or in any period also. So there are two types of sending of patent. One is manual and second is the e-type of. Now where to send? There are four offices. One is Mumbai, Kolkata, New Delhi, and Chennai also. So these are the particular offices where we live in that area. In the judicial area, we can file the patent. Maharashtrian can file the Mumbai, Chennai, New Delhi, Kolkata. All these things are different offices where we can file the patent as per depend upon the address from which area we are coming. So we can, Maharashtrian can find in the Mumbai. Okay, let us go. Who can file the, who can submit the patent application? मित्रो, पेटेंट हा विषय किंवा प्राध्यापकाचा नाही, ज्युनियरच्या सिनियरच्या नाही. पेटेंट हा विषय प्रत्येक भारतीय नागरिकाचा आहे. मेकॅनिकल, इंजिनियर, डॉक्टर्स, शेतकरी, शेतमजूर, कोणत्याही इंडस्ट्रीचे व्यवसाय कुणीही पेटेंट दाखल करू शकतो. सो देयर इज नो क्वालिफिकेशन, नो देयर इज एज लिमिट फॉर द पेटेंट. सो लेट अस सी हू कॅन फाइल द पेटेंट. One, first of all, the applicant himself, known as the true or the first inventor, can file the patent. Firstly, secondly, we can file jointly the application also. Means someone is working under one supervisor, few research scholars are working under some supervisor, then they can file jointly that innovation, because everyone is contributed for innovating that idea. So patent can be filed jointly. Thirdly, you can file your patent through the assignee. आप घर पे आराम कीजिए, एक लेटर दीजिए पेटेंट ऑफिस को कि ये आदमी मेरा पेटेंट लेके आ रहा है, इसे कृपया आप मेरे नाम पे फाइल कर दीजिए. So you can file the patent through your assignee by resting on your home also. And fourth is the through IPR agent. IPR agent are not like our RTO agent, but these are the qualified persons which are qualified from the patent office examination, and they have license for guiding the people. So by through the authorized IPR agent, we can file the patent also. And lastly, if someone have died before filing a patent, किसी की कोई दुर्दैवश मृत्यु हो गई, पेटेंट फाइल करना रह गया, तो by the legal representative of any dead person, that वारसदार can be file the patent. The representative of that, legal representative of that person can file to the patent. म्हणजे त्याचा अर्थ असा आहे, पेटेंट एकदा तयार झाला की कुठलीही शक्ती त्याला अडवू शकत नाही. पेटेंट आपण दाखल करण्यासाठी सगळ्या प्रकारच्या सोयी उपलब्ध आहेत. Now let us see the patent filing forms and fees. As let Suhas Kulkarni also said the patent filing forms, but just I would like to repeat patent filing forms and fees. Patent form, there are so many forms available on the website for filing a patent, but all patent forms are for a particular purpose. For getting a patent, there are 4 forms are necessary. First of all, form application for patent with fees of 1,600. Second, complete specification form, there is no fees, but it is compulsory one. Third, request for publication, and form number 9, request for publication. Form number 8, request for the examination. Let us see. After filing the patent, we have to request to the patent office for publication by paying the fees. After that, we have to request the patent office for the examination. After that, filing forms and paying the fees, patent office proceeds for publication and granting of the patent. Let us see which are the different types of filing of patent. We have seen the different files of sending the patent. Now see who can. We have seen the who can file the patent. Now see the types of filing the patent. There are two types of filing a patent. One is the provisional filing and second is the complete filing. Let us see what is the provisional filing. Provisional filing means that if you want to file a patent, but still you have not completed all the process, all the details not you have, but only is title in is your mind, then you can file that patent provisionally by using form number 1 and particular fees. Means just title, writing some abstract, and with that particular fees, you can file the patent for provisionally. After that provisional filing, you have to complete file within 1 year. Otherwise, the provisional filing gets lapsed. Means within 1 year, one can file the detail of that patent. That is known as the complete specification within 1 year. For that, you require form number 1, form number 2, form number 9, form number 18 plus fees and detailed drafts, drawings and sketches used for that patent. Means you can submit the patent provisionally, or you can submit your patent complete specification. If you are completely ready with your patent, then there is no need to file provisionally, but you can file complete specification also. So there are two types of filing a patent. One is provisional, one is complete. One can go through the both process or single process also. Let us see what happens after the submission of our patent. First of all, we have to submit submission. That patent office, after filing, paying the particular fees, if that person have paid the fees of examination and publication, then only patent office publish the patent, and then you receive the first examination report from the patent office. Means after examination, the first team of that examiner give the report to us, emailed to us. Then if we have answer very satisfactory within 1 year or within that particular time to the patent office, if the patent office is satisfied with that answer, then they can issue the patent certificate. So submission, publication, giving answer to the first examination report, or giving if necessary to the second queries given by the patent office, and then you can get the patent, or patent office can grant the certificate to you. Then after getting a patent, you have to renew it. We have to renew it. Don't be relaxed getting after a patent. Means after, if you publish a patent, up to first 2 years, there is no any fees for a patent. But after that, there is fees up to 20 years, as like Kulkarni sir said, that patent will be enforced on your name at 20 years. But we have to pay the fees of the particular patent for 20 years. Let us see the terms of the patent. First term is the patent is 20 years if you paid the fees. Second is copyright is 70 years term, or up to the life of that inventor or that writer. Design have 15 years of the life, and trademark is 10 year. But after 10 year, you can renew the trademark. Because of that, only the companies from the 100, 200, 300 years are using the same trademark, because they are renewing. There is opportunity, there is chance, there is provision for renewing the trademarks, but not there is provision for renewing the patents, copyrights, and designs and plants bidder rights. Because plants bidder right also gets lapsed after 15 years. But any fees, if you want to pay, there is no any acceptance after that. म्हणजे 15 ते 20, 70 अशा वेगळ्या पर्टिक्युलर नंतर ते नॉलेज जगाला ओपन होतं. किती फीस भरली तरी आपण आपल्या नावावर ते पेटंट राहत नाही. म्हणून पेटंट, कॉपीराइट, डिझाईन्स and plants builder right have particular time if you pay the particular fees, but trademark is not a particular time. It can be renewed after every 10 years. Let us see the renewal fees of a patent. For 2 years there is no fees. For 6 years there is 2,000 fees. I like this. For 20 years we have to pay 20,000 rupees to enforce the patent on our name. If we not paid on that, it becomes the property of government, and anyone can use that knowledge of your patent. Let us see the top 10 countries filing the patent. First of all, China is topper in the world for filing the patent. Then US, then Japan. India is on 7. As like Kulkarni sir said that there are lots of patent filing in China, but there are thousands of patents India is filing in the same year. So we are so much lagging behind for filing a patent. If some academicians, industrialists, student, research scholar, and every citizens try to innovate something and file a patent, then the rank can be go ahead. Let us see the situation of Maharashtra. Maharashtra is number one in our India for filing patent, and most lowest is the MP is the most lowest. So Maharashtra is a proud thing that we are leading in our country for filing a patent on a proper way. Let us see about the right of the patent. Means patent rights are not universal right, but patent rights are related to judicial rights. Territorial rights means if you file a patent in India, then you can get the right only patent in India only. If someone is selling that product and duplicating that product in Pakistan, Bangladesh, or neighboring country, we cannot do that. So we have to file the patent in that particular country for enjoying the particular rights for that. So that if we want to file patent in other countries, there is also a provision for filing a patent in other countries also through India, and you can get the benefit of your patent in that particular countries. More than 50 countries as India have assigned to other countries, you can file the patent. Single file can give the right in that particular countries. Let us see the one court judgment of the copyright, which was in the US court. Means what happened here? One person known as the David J. Slater have kept his camera, wildlife animal photographer, in the jungle. Then what happened? That monkey shooted his photograph, and that photograph was submitted to US court. That photograph was submitted by David J. Slater to the Wikipedia. So Wikipedia granted copyright to the David Slater, but David Slater denied that copyright because that photograph is not my own, but that photograph is from that monkey. But the US court judgment said that a monkey could not claim a copyright. Means to have claimed our copyright, to enjoy the right, someone should be human one. So a monkey or animal cannot get a copyright or any IPR. It is the judgment from the US court. Let us see the next slide. Sorry. There are 4 questions I would like to share with you related to this work. Let us see. First of all, can we patent our coronavirus? कोविड-19 आता जो काळ चालू आहे, कोविड-19 मुळे आपण सर्वजण ऑनलाईन प्रक्रियेमध्ये आहोत. पूर्ण देश आणि जग ज्या संकटामध्ये आहे, त्या कोरोना व्हायरसचं आपल्याला पेटेंट घेता येतं का, ही शंका आपल्याला निश्चित आली असेल. कॅन वी पेटेंट कोरोना व्हायरस कोविड-19? No coronavirus can be patented because coronavirus is identified in 1962. Then in 2005, few species of them added, and in 2019 in December, all literature is open for the public. So coronavirus is known in the literature in 1962 in the geography papers. So coronavirus not innovative, not new. It is identified few years ago. It is known to the literature. So that cannot be, coronavirus cannot be filed for a patent. Secondly, coronavirus is a live, means it is a species, that is live species. So any live species, plant or live things cannot be patented. जसं आपण अगोदर म्हटलं, प्लांट, एनिमल, त्यांचा कुठला पार्ट, जिवंत असणाऱ्या वस्तूचा आपण किंवा नैसर्गिकपणे जन्म घेणाऱ्या कुठल्याही गोष्टीचा आपण पेटेंट घेऊ शकत नाही, कारण त्यांचा जन्म नैसर्गिक आहे, त्यांची वाढ नैसर्गिक आहे. सो दॅट कोरोना व्हायरस इज वन स्पेशीज, लाईव्ह स्पेशीज, सो वी कॅनॉट फाईल द पेटेंट. अजून दुसरी एक महत्त्वाची गोष्ट अशी झालेली आहे की कोरोना व्हायरसच्या पेटेंट ड्रगवर ग्रँट द्यायचं नाही असं ठरवलेलं आहे. कोरोना व्हायरसच्या ड्रगवर पेटेंट द्यायचं नाही अशा जगातल्या ड्रग कंपनीने आणि मेडिसिन कंपनी ठरवलं असल्यामुळे कोरोना व्हायरसवर पेटेंट नाही किंवा कोरोनाच्या औषधावर सुद्धा पेटेंट नाही. हा पहिला प्रश्नाचा उत्तर झाला. लेट अस सी द सेकंड क्वेश्चन ऑन द स्क्रीन. कॅन यू पेटेंट युअर नेम? आपलं नाव आपल्याला पेटेंट करता येतं का? If our name is new, it may be copywritten. But if name is known, if name is old, if name is known to all, we cannot copyright our name. Now, the third, can you patent our DNA? We cannot patent our DNA because it is natural one, and if we break some DNA chain and if you innovate something for that, then and then only it can be patented. And secondly, last question, can you patent yourself? हम खुद का पेटेंट ले सकते हैं क्या? हम खुद का पेटेंट नहीं ले सकते because we are naturally born and naturally progressing. So these are the 4 questions I would like to share with you. I am so much thankful to all the academicians, university authorities for giving me opportunity here to express my thoughts on the patent. After a beautiful explanation of respected Kulkarni sir, I would like to thank to Honorable Vice Chancellor sir. I would like to thank to Registrar of this university. I would like to thank to Dhananjay Mane sir, Dr. Dhananjay Mane sir, which is giving, which is more taking more effort for conducting this webinar. So I am thankful to all, and the session is open for the discussion. Thank you, sir.
I appeal to all the participants, if you have any queries, then ask one by one.
Hello, good evening, sir. If a person register a patent abroad, can he register again in India?
Yes, sir. We can register patent because, as like sir said, that so many people are applying for the patent in India also. If you file a patent in India, within 6 months you have to file to out of country also. So out of citizens can file in the India. Same thing, we can file the patent on other countries also.
Okay, thank you. The next second question is, sir.
Yes,
how
sir.
much time lapse is there between provisional registration and complete registration?
Provisional patents, after completing the provisional process, we have to file within 1 year. Or if the guidelines are changed by paying some fees, very less fees, you can extend your time. But best way is within 1 year you can file very detailed manner, because you have subject in your mind, you have some draft in your mind, so we have to go proceed. Because of this time limit we are filing. म्हणजे आपल्याला कुठेतरी बंधन झालं म्हणजे आपण ते काम करतोच. तसं आहे. 1 वर्षाची मुदत आहे, थोडे बहुत पैसे भरले, अजून पुढे टाइम वाढू शकतो, परंतु आपण असं ठरवायचं की माझं पेटेंट वर्षाच्या आत मी चांगलं करेन. हा जर उद्देश घेतला तर निश्चित आपण ते पेटेंट चांगलं टाकू शकतो. बोला सर.
Okay, thank you, sir.
Okay, sir.
Sir, there is one question from the audience.
Yes, sir.
Dr. Sudhir Bhatkar says, is there any process to file a patent in social science?
Sir, if there is equipment, if social science person or any domestic person can innovative some equipment, then it can be filed. म्हणजे समाजशास्त्र असो, होम सायन्स असो, एखादी महिला असो, गृहिणी असो, मेकॅनिक असो, शिक्षक असो, प्राध्यापक असो, अजून की शिक्षित सुद्धा व्यक्ती पेटेंट फाईल करू शकतो तो IPR मधून. म्हणजे जरी सोशॉलॉजीचे सर असतील, इफ ही इज फ्रॉम सोशॉलॉजी, ही इज युजिंग पेन ऑल्सो, ही इज युजिंग वॉच ऑल्सो, सो ही कॅन फाईल द पेटेंट ऑन हिज इनोव्हेशन ऑल्सो. देर इज नो problem of subject and qualification.
Thank you.
Okay, thank you, everyone. I would like to thank Dr. Bhatkar sir for his valuable guidance on the patent and IPR. Because before joining this session, we would have so many queries, and I suppose that so many questions will be there. But your nice information would not arise to get the too many queries from participants. Means they understood what you said. Basically, we hesitate to ask the questions, but through your lecture, you solved all your queries. Even though I asked 2 questions, because long back I wanted to ask to someone, but no authority to ask some questions. So today I got opportunity to ask this question. And I got the queries. So from my bottom of the heart, and on the behalf of the SICA, I would like to thank you, as well as I would like to thank Dr. Kulkarni sir, who is the Assistant Commissioner of the Patent Office. I would also like to thank our Honorable Vice Chancellor sir. He has given permission to take this workshop or seminar, national level workshop. And let me tell you that we received almost more than 800 participants. And that's why we have shown this to the through the YouTube channel also. Live webinar is going on YouTube also. So many participants are attending through the YouTube also. So I would definitely like to thank our visual team for supporting this kind of the system. I would also like to thank the SICA director, Dr. Gunjal sir, who has come over here and elaborated on the many aspects of the SICA and what is going on in the SICA also. I would also like to thank the convener of the today's program, Dr. Dhananjay Mane, who is acting as the regional director of Nasik region. And because of him only, this today's seminar could took place. I would also like to thank our planning officer, Dr. Hemant Rajguru sir, because he has taken the initiative to get the approval from the Vice Chancellor sir and to conduct such a nice seminar on the IPR and patent. I would also like to thank all the participants who have joined through across the different parts of the India. There are so many participants from the Tamil Nadu, Andhra Pradesh, Bihar, then Madhya Pradesh, Gwalior region, from all the participants from different corners of the Maharashtra itself, from Hausa, Latur, Udgir, Mumbai, Aurangabad. So many places are there, and such a nice workshop is conducted because of them only. So I would like to thank all other authorities of the university, and I, with the permission of the chair. One request is there, we have designed the feedback form. Those who want to get the certificate of today's function, they have to submit that feedback form, and automatically they will get the auto-generated certificate. So there is a limit per day, 100 certificate you could get. Suppose you are not, there is no acceptance of the responses from Google form, then wait for today and again apply tomorrow. Because it is, suppose it is not accepting means the limit is crossed, 100, total 100 certification is crossed. So you have to apply again tomorrow and you will get definitely the auto-generated certificate. So on the behalf of the SICA, I would like to thank for all. Thank you very much.
Thank you.
And
Thank you.
with the permission, this session is closed.
Thank you very much.
Thank you.